she even took it a step further, saying a lot of the written documents they gave to her as pictures, right, as JPEGs, which means she couldn't search within the documents. Yes. So it made it even more difficult.
This whole case, I will say this, whether or not there are grounds to overturn, that's the court's decision. But I am going to suggest that this whole case to me has been riddled with things that should have been done differently. It should have been handled differently. Now, having said that, Bob, everything you just articulated so well, and I'm uncomfortable, like Michael said, watching her have to divulge all of this information. Do you think it's enough? Does it equal ineffective assistance of counsel? Not because of maybe her and her skill set, but rather all of these other things that you just described.
Well, you know, George, I hate to go back to the old definition of, like, when they say, what is pornography, and then the old adage from the United States Supreme Court. I can't really define it, but I know it when I see it. And there's a lot of truth in that in my experience with PCRs. Again, they're not redos. They've got to be done on ineffective assistance of counsel. I wrote the three main areas here. Ineffective assistance of counsel, newly discovered evidence is another area. But I think that when a judge sees something and the judge is moved to the point where they say, like I feel right now, listening to this limited amount, that I believe an injustice may have occurred here that could have affected the decision, then you're more likely going to get the reversal.
Yeah, that's really what it boils down to. And I don't feel like, Bob, that we've gotten there yet. There's still a lot more testimony to go. But again, let's jump back to this idea of prosecutors and the way that they handle these cases. And I'm glad you said this, because I want to hear, I was going to ask you, is there a standard, a universal standard, national standard, as to the process of turning over discovery? Because it clearly seems to me, having been in the system, watching trials, et cetera, that the way this stuff is handed over, this discovery, is really a big part of creating advantages one way or the other, particularly in most cases for prosecutors.
Yeah, great question. And again, we're getting back to that issue. Like, for example, I'm involved in something now where we're trying to explain, and this is what I'm really curious if she brought this forward to the court. We have that, and I think sometimes the courts may not understand that when you get this kind of thing happening to you, I can have 4 or 5 lawyers working on it. We're still 7 months later in this particular case that I'm dealing with, sifting through trying to figure out where the discovery is. So, yeah, it could affect it. I know we got to move on. I'll have a bigger answer down the road.
All right, fantastic. All right, Bob, really fantastic conversation.